Hello everyone. Today I want to talk some more about monetized installment sales, sometimes referred to as transactions under code section 453. I know that sounds boring and whatnot, but a lot of people have done monetized installment sales over the years. They've been a valuable tool for tax deferral of capital gains, long-term capital gains. They've been an important tool for as an alternative to a 1031 exchange or just paying the tax in general. So I want to talk about them because earlier this summer, we're doing this video now today in January of 2022. Earlier this summer in July, I think of 21, the IRS came out with, sort of it's what they call its dirty dozen list of transactions that are suspect, and the monetized installment sale was on there. And so a lot of people kind of ran for the hills trying to decide what to do. The dust has really settled a lot, and when you go to the IRS website, if you see anything published by the IRS, the way they style it in their caption is they use the word, they start it with improper monetized installment sales. And I would focus very quickly on the word improper. When we set up a monetized installment sale and facilitate that, we do it correctly, we do it the right way. Of course, anything that is improper is wrong from the beginning, but just because there's a monetized installment sale does not mean that it's improper or illicit or illegal in any way. Installment sales have been around forever. Loans have been around forever, because at the bottom line of this transaction is really two steps, two different parts. I wouldn't even call them steps, but there's an installment sale for usually a long period of time to defer capital gains. And then there's an income stream from it that you can then elect if you want to, and if it's according to your business and estate planning purposes, to take a loan against that income stream and monetize the income stream, so to speak. And when you do that, that's what you get for the transactions that are being referred to as monetized installment sales. And loans against income streams have been around forever. That's what we do with a piece of real estate. When you have income producing real estate, you have rents coming off, that's your income stream. You go to the bank, you say, I'd like a loan based on my income stream. And they look at it and they value your property according to the cap rate, the capitalization rate, based on the income stream. And then they give you a loan based on that. That's what is going on here. It's a refinancing method. And if it's done properly, which we try to do things properly, then it's okay. And the groups that we're working with have developed a very close relationship with the IRS. There's no hiding, in the weeds here. We work closely and directly with IRS to make sure that your transaction is done correctly, it's done properly, and that you're getting what you believe that you're getting. And when you go through that, the next layer really of protection beyond the information that I provide, and I can provide some backup articles and law reviews and different cases that have come down in bankruptcy court and other places, actual law, like real law, not opinions you hear in the media, but actual law and actual cases and actual opinions from the IRS and from their general counsel on this very subject. And when you look at the real law, you realize, oh, there is a way to do this correctly, and I can have incredible tax deferral benefits, as well as possibly a loan against it, and have a lot of cash and a lot of liquidity. So what we would recommend, and we've just done this recently on one of our cases, is to get an opinion letter by outside counsel so that you can say, look at my transaction, look at my transaction documents, the actual documents, look at my letter of intent for this transaction, and look at the entire scope of it, then look at the law, and then get an opinion, a legal opinion, whether your transaction is supported or not supported by the law, and then make your decision about going forward one way or the other. And the way we do it, there's no commitment. You can back out if you don't like to, if you think you get a bad opinion letter, or the opinion is that you're doing something wrong, then you would not do the transaction. No harm, no foul, no cost other than the opinion letter. And that's a very prudent careful and wise way to manage your business, just like you get legal advice on anything. So the opinion letter really is one of the most important things you can do with these monetized installment sale transactions, 453 transactions as I call them, because it gives you the assurance of your deal. How is your deal going to be treated by the IRS, and whether you have good legal standing to move forward or not. And it clarifies your transaction versus, well, there's a lot of other things that have happened, and what about this fact pattern and that fact pattern? Maybe it's different or distinguishable from yours, and you're nervous, and rightly so, right? Nobody wants to get an IRS audit. So look at it in an opinion letter based only on your transaction. That way you can make an informed decision about whether to go forward or not. Or maybe another way to look at it is if there's a defect in the structure of the transaction, you might also decide to alter the transaction so that it becomes more compliant or becomes fully in compliance. So that's it for today on installment sales. I wanted to talk about it because they're in the news and they're a hot topic, and we get a lot of calls on it, and I like to give people good information. And really, I think when you look at the real law of what's happening, and when you get an opinion letter, that can really help you make a good decision and move forward on your transaction one way or the other. That's it for now. If you've got any questions, of course, give us a call or an email. I'd love to hear from you. Thank you so much.